Hello there, and welcome to another edition of our interview series for the federal workforce. Today we are talking about federal employment law. My guest is Steve Lewicky. My name is Brian Kuhn, certified financial planner with Wealth Enhancement, and my focus is federal employees. So, Steve, welcome to the program. Appreciate it.
Yeah, good morning, Brian. It's great to be with you. Nice talking to you today.
Yeah, good seeing you again. Tell us a little bit about yourself and your area of law.
Sure. Well, I'm an attorney. I practice in Maryland and DC. Our offices are in Howard County, Maryland, but we practice throughout the state. My focus is on business related, both transactions and litigation. And as part of that, we do a fair amount of work with government employees.
Yep, and certainly a lot going on. We're going to talk about it today. So, with all of the recent turmoil in the government employment, what are you seeing in your practice currently?
Well, we're getting a lot of calls from people who are concerned, both government employees and former employees, government contractors. And we all know from the news that things are happening quickly, and what we talk about today might be dated in a few days. But as of today, the kind of hot topics are that there have been cases in two federal courts that have recently resulted in temporary restraining orders. One of those cases is here in Maryland, the other one's in the Northern District of California. And the Maryland case, well, both of the cases issued orders that stayed the government's efforts to kind of wholesale terminate what are called probationary government employees. And that's a very large number of employees. I'm not sure they have an exact number even now, but it's thousands of employees that have gotten notices in recent days or weeks telling them they were either on administrative leave or in many cases dismissed from employment. So what the federal court in Maryland has recently said in an order is that it's not lawful for the government to simply wholesale terminate large numbers of probationary employees without giving or having a reason related to their performance. The government's taken the position, or is interpreted to have taken the position, that they can just say, you're fired. And the court looked at the relevant statutes and said, well, no, you really can't do that. You have to actually tell the probationary employees that there's some reasonable basis based on their performance. And you also have to give prior notice to these employees, and that didn't happen. So the news as of this morning is that the federal court has ordered that all of these probationary employees that were terminated be reinstated immediately by the government. And the court also ordered the government to give basically a written status report by yesterday about those reinstatements, which the government did do. And so we're all kind of waiting and trying to figure out what is the next step. The government, just to be clear, is allowed to terminate employees, and they are allowed to terminate them either for cause or just to reduction in force. But the government has to follow the rules, basically.
Right.
And the statute and the regulations have pretty clear and distinct rules about how that's done. And so far, those rules, at least in the holding of these two courts, the government hasn't done that. So that's where we stand as of this morning.
Mm-hmm. Interesting stuff. And just for reference, for those watching, we're recording this on March 18th, so we'll get it out as quickly as possible and then have continued conversations with professionals as things progress, so we get as much information out there. So we have the situation with the probationary employees, the status there. But if the government goes back and does things differently, can the administration lay off large numbers of federal employees?
They certainly can. The government can if they follow the rules. And government employees' employment is not at will the way that many private sector employment relationships are. At will in the private sector means that someone can be terminated for any reason or for no reason, as long as it's not for discriminatory reasons. In the government, government employees have rights to appeal any termination. And the asterisk here is that probationary employees in the government have far fewer appeal rights than do non-probationary employees. The term probationary is a little misleading because it doesn't mean that you were hired a week ago. A probationary period can last for a year, even 2 years, and it isn't necessarily the first year that you were in the government. It could be the first year that you're in a new government job. So even if you've been with the government for, say, 10 years, if you change to a new position, you might be probationary for, let's say, a year in that new position. So anyway, the probationary employees do have some appeal rights, but fairly limited. Everybody else that's employed by the government has the protections of the Merit Systems Protection Board. And basically, if they're terminated for cause, then the employee can appeal that, can go to the Merit Systems Protection Board and lay out a case of why they were a good employee, why they were doing their job. And to answer your question, the government can terminate people either for cause or through a system called a reduction in force. But a reduction in force also has rules where you have to give particular notice. You have to give them an opportunity to find other employment. And in some cases, the government has to actually tell states where the employees live that a reduction in force is in the works, so that the states can then better support those employees. The courts that are looking at it have said that so far the government hasn't been very good in following those rules. So again, a lot is going on in the reduction in force area, and also purported just terminations for cause that the government has tried to do. So there are a lot of federal employees that have either been placed on leave or have been told they're terminated that almost certainly have appeal rights that they should pursue. And the Merit Systems Protection Board has the ability to order reinstatement of an employee, to order that they get back pay, and in some cases to be reimbursed their attorney's fees.
Mm-hmm. All right, very good. And then you mentioned contractors and subcontractors. A lot of them, their worlds are changing as well. What's the latest there?
Sure. Well, that's also an area that there's a lot of angst right now. We have a lot of federal contractors, subcontractors here in suburban Maryland. I mean, the short answer with contractors is the contract terms govern what can be done.
Right.
And so every particular situation depends on that particular contract, and it's important to look at that contract. But speaking very broadly, almost every government contract does have what's called a termination for convenience provision, where the government is allowed, if it wishes to, for its own convenience, to terminate a government contract, regardless of whether the contract's being performed properly by the contractor. But if it is a termination for convenience, the government does have to compensate the contractor for costs associated with winding it down, for ending the contract. And so there are a lot of kind of procedural guardrails in place where if a contractor gets like a notice to stop work, the contractor does need to immediately stop work, but the contractor also needs to carefully document any costs that they're getting associated with that termination or wind down, because those are all going to be compensable from the government. And likewise, there are almost always notice provisions. It depends on the particular contract, but the short answer is the government has to follow its own contracts, and that often includes compensating contractors for the reasonable cost and also the reasonable anticipated profit lost from work actually completed before the termination, but not yet paid as of the date of termination.
Makes sense. That's a helpful clause for the contractors to be in there, but unlike going to the MSPB, I bet they have to work that out, maybe by contacting somebody like yourself to file a claim for it or something.
Yeah, and I don't want to go into all the details, but at a high level, there is a process. If a government contract is terminated, there's then a process whereby the contracting officer for the government tries to negotiate or work with the terminated contractor to come to a settlement, basically, and it's a set process for doing that. And in an ideal world, a settlement is reached, it's fair to everybody, everyone signs off, and it's paid. But if the contracting officer and the contractor are not able to come to an agreement, then at some point the contracting officer formally says, okay, we weren't able to come to an agreement, the contract is over anyway. And then that's when the time periods kick in for the contractor to note a formal appeal, and they can appeal either to the particular agency's contract board or to the U.S. Court of Federal Claims. There's some very tight timelines and very precise timelines, both for when that has to be done and the things that have to be put in the document. So it is very important that contractors closely follow the rules and watch the clock. And, from my perspective, I think that almost always an attorney should be consulted and used, because if you don't do it just right, you're out of luck.
Yeah, interesting stuff. All right, well, thanks, Steve. Appreciate it very much. We look forward to having you back. We'll get some more updates. For those who are watching this and want to talk to you directly about some events that might have affected them, how can they get a hold of you, and what should they expect from that conversation? We'll have your contact information up on the screen.
Sure. Well, I encourage anyone to contact our firm either by email or telephone. We provide initial consultations to people where we sit down either by Zoom or in person for an hour and discuss the case. And then based on that information, the client can decide whether to take further steps or retain us or not retain us. So we're talking to a lot of people these days, and we're here to help.
All right, very good. And as for myself, again, Brian Kuhn, certified financial planner with Wealth Enhancement. My focus is federal employees, 24 years helping them plan for their retirement and personal financial goals. With everything going on, we are offering a complimentary consultation. We can visualize your retirement, map out a cash flow model, help make some decisions, and just make sure things are going to be okay. So we're here. Contact us as well if you would like. We'll be back with another interview shortly, and appreciate your time.
Thanks, Brian.
Brian Kuhn is a certified financial planner with 24 years experience in the industry. He's the author of Total Compensation, a practical guide to federal employee benefits, and the host of Federal Workforce Uncertainty.